You have the right to remain silent.
But we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law.
Spinning the Law
Spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, folks, welcome back to the Steve Malzberg Show. And kicking off our first Spinning the Law segment of the year is our friend Kendall Coffey, of course, a famed attorney and author of a book by the very same name. Hello, Kendall. Happy New Year.
Well, Happy New Year to you, Steve, and all your listeners.
Well, I appreciate you coming on. Always appreciate your time. And we have a lot to talk about here on this first of the year. And it started New Year's Eve, Kendall, with what to me, as I'm just, getting ready for New Year's Eve, that means, some Chinese food and watching the ball drop. Nothing exciting. Actually, there was a blackout in my town for 20 minutes while I was in the shower at 6 o'clock.
Oh, no.
So that was fun. But that aside, it appears that, not it appears, but Sonia Sotomayor, U.S. Supreme Court Justice, blocked the Obama administration, temporarily albeit, from forcing an order of Catholic nuns to comply with the federal requirement in Obamacare to provide free contraceptive coverage for employees. That's a two-sentence decision or two-sentence order, and it gives them until tomorrow, January 3rd, the deadline for the administration to respond. But this could have far-reaching effects.
Yeah, the implications are dramatic because this involves two of the giant controversies of today. Obviously, Obamacare and the rights with respect to religion and the issues that we've all talked about so many times with respect to religious objections to contraception. So this is huge. What a way to start the year. And these kind of procedures where somebody is getting a stay, that is in order just to block the decision until it can be fully reviewed and briefed, are nonetheless incredibly important. You recall the stay, the same kind of blocking order that was entered by 5 justices of the Supreme Court that shut down the recount in 2000.
And you were directly involved in that one.
I was, and Scalia famously said, look, you've got 5 people who are granting a temporary freeze on what is going on. That means that's a pretty strong signal as to how this case is going to turn out. So we've all got to be kind of sitting on the edges of our seats a little bit to see what happens after tomorrow when the briefs come in, when the full Supreme Court, I assume it's going to be the entire Supreme Court, is going to have a chance to weigh in on whether this particular provision of Obamacare is going to be enforceable in light of the religious rights of the nuns and the religious rights of many who have objected to the idea that they can be forced in some way, their health care plan, to participate in support of contraception. Now, the Obama administration modified the rules a little bit. You remember that when the objections first came out. But at the end of the day, whether or not this order of nuns, the Little Sisters for the Poor, has to, out of their own health care plan, pay for contraceptions, they're objecting because they would have to certify, in effect, and allow their insurance company to make a payment for something to which they have strong, deeply held, and religious-based moral objections.
Yeah. Now, Kendall, this differs, I guess, from back in the end of November. The Supreme Court agreed to hear 2 cases brought by business owners, Hobby Lobby and a wood specialties store. But those are private companies. Here we're talking with the nuns involved here. We're talking obviously about religious institutions. So they're separate, are they not?
Well, there is an important distinction to be made. It's possible the court could find that whether you're a religious organization or you simply have your own personal objections to contraceptive insurance coverage, that you stand with the same rights. But what a strong case it is when you're presenting something on behalf of nuns who operate 30 homes for the elderly and the sick, who obviously have the most legitimate kind of religious objections to this provision. And again, no, Obamacare does not require that this be provided specifically in their insurance policy, but the nuns would have to certify that their insurance company is authorized to pay for contraceptive coverage out of its own funds. So they may not find that's a distinction because either way they would have to provide some support for contraceptives.
Yeah, it's going to be very, very interesting to see what happens. But I was just kind of surprised by Sonia Sotomayor's ruling. But maybe I should not have been. You can never predict what a Supreme Court justice will do, I guess, right?
Well, it's hard to know. And this Supreme Court, whatever you disagree or agree with it, has consistently had a very strong position in favor of First Amendment issues, rights of free expression, religious rights, and so. When you have a group of literally nuns coming before them saying, don't make me participate in this, it's wrong, it violates my most fundamental beliefs, everything I believed in my life, pretty compelling stuff.
Yeah. All right, let's move on, Kendall, to another, this is a federal court decision. They've tossed out a lawsuit trying to prevent the government from searching laptops, cell phones, and other devices at U.S. border checkpoints. It was a circuit court judge's decision. He upheld the Department of Homeland Security's policy, and of course this goes against, it's considered a blow to the civil rights groups that argued that the practice violated the Constitution's protection against unreasonable search and seizure. According to the government documents, officials at the border search and copy the contents of thousands of people's devices every year, and border agents are allowed to look into the devices and detain them for a short period without a reasonable suspicion that the traveler has committed a crime. And of course the ACLU and the National Association of Criminal Defense Lawyers filed this lawsuit.
Well, as you know, the government, the agents, TSA, they have more rights to ask you for information and to conduct limited forms of searches when you go through airports, you go through border crossings. The issue here is not whether they needed a search warrant. I don't think anyone is seriously insisting that they did. But there's a standard when you do more in a simple search or a simple look-through and you detain somebody briefly, or you detain, in this case, a laptop, called reasonable suspicion. And you're supposed to have reasonable suspicion. Obviously, it's not as much as probable cause. It's more than simple whim or fancy. And it means that they've got to have some basis that they can articulate as to why they want to hang on to somebody's laptop and do a more extensive search. Here, the laptop seemed to be from a individual who had been in, I think, Lebanon for 11 days, who had pictures of demonstrations of Hamas and Hezbollah, and the judge really had no difficulty finding that that was enough to constitute reasonable suspicion for purposes of a more extended search of the laptop. I don't think it should be a very controversial decision. All of us are concerned about having our private files and our private information searched, but think about it this way, Steve. If, in fact, it came to pass that somebody who'd been to Lebanon for 11 days, who had been doing a filming of demonstrations of groups like Hamas and Hezbollah, later was implicated in something terribly wrong, and it turned out that nobody bothered to search through his laptop. Can you imagine the outrage and the outcry that would ensue from that?
Absolutely. No, without a doubt. I mean, especially in the case of the person we're talking about, it seems like it's absolutely reasonable. I think the only doubt might come in where they say they don't need a reasonable suspicion to detain these computers and cell phones. But I'm with you. You know, if it comes to national security, which leads us, and we're talking to Kendall Coffey on our Spinning the Law segment here on the Steve Malzberg Show, which leads us to the next story. And that is, last time we spoke, we discussed the court decision on the NSA case brought by Larry Klayman, where he won, and the judge called the NSA program saying it probably violated the Fourth Amendment of the Constitution. Big victory against NSA. Everybody went nuts. And now you have a decision by a judge that is a court that is just on equal footing to the court that made the decision, but in a different location, obviously, saying that the NSA program is perfectly constitutional and needed, in fact, to thwart the likes of Al-Qaeda and how they operate. And it's a complete antithesis of what the other judge ruled in saying there's no evidence that it does anything to help combat terror. So you couldn't have had two more completely different rulings on this same issue.
And just remind us that you can't always predict these things. The judge that objected to NSA surveillance was a George W. Bush appointee. The judge that is validating NSA surveillance is a Clinton appointee. But here's the issue. Since 1979, the U.S. Supreme Court has said it's pretty clear that information from your phone as to who you're calling and how long the duration of the phone call is not confidential or private information. It's part of what used to be on our telephone bills. So there isn't that constitutionally protected level of protection for the mere fact of phone calls and the duration and the numbers. There's a whole lot of other information out there that is equally accessible all the time to the authorities. So if they use phone numbers, if they use the duration of the calls, and they try to construct a detailed profile of Kendall Coffey or Steve Malzberg, first of all, they might fall asleep. That's probably not as exciting as we might think. But beyond that, I think that's going to be perfectly constitutional. I understand why many of us are uncomfortable about the fact that the government has so much information about all of us, that the government can do so many things to collect information and analyze it and probably predict where we're going for New Year's Eve next year. But the reality is that there isn't a constitutional protection from those bits of information one at a time. So putting it all together, which is what the existing capabilities allow, doesn't turn it into a constitutional violation. If knowing the phone number you're calling tomorrow and how long you're on the phone, if that's not a constitutional violation, and then collecting all the calls you've made over the last year, analyzing it, breaking down with other information in the Steve Malzberg database, that's not going to be a constitutional violation either.
Very interesting, and we'll see how this is eventually decided, probably again by the Supreme Court. Who knows? All right, listen, Kendall, always a pleasure. As you know, thank you for accommodating us today, and stay well. We'll speak to you in a week, hopefully.
It's 82 degrees down here, Steve. Just think about that.
Yeah, I know. Well, the wind chill is going to be minus 10 on Saturday, or actually tomorrow. So, let's see, 80, minus 10. It's a tough choice. Thank you, Kendall, for that weather update as well. Kendall Coffey, ladies and gentlemen, the great Kendall Coffey on the Steve Malzberg Show. All right, folks, lots more ahead. Don't go away. We were just spitting the law with the great Kendall Coffey. Steve Malzberg Show, Newsmax TV and radio.